That's a good question, and it comes up all the time. I've been representing very capable and successful individuals for 23 years now, and it's a question that comes up all the time. Mostly in the context of physicians and doctors, psychologists and psychiatrists. Before I answer the question, I think it's important that I first go into how courts interpret the own occupation provision in most long-term disability policies. And most policies will read, you are totally disabled, and I'm putting in air quotes there, totally disabled, if you're unable to perform the important or the substantial and material duties of your occupation. That's important to know. What is your occupation? Well, courts interpret it to be the actual occupational duties that you were engaged in immediately prior to the onset of your disability. Of course, there may be a few exceptions here and there, but that's a general rule. So, for example, if you were an orthopedic surgeon and you performed surgeries 3 days a week, but then you had an administrative aspect to your occupation. Let's say you were running the orthopedic clinic, or you were in charge of hiring and firing various nurses or other personnel in the department. Your occupation would not only be that of an orthopedic surgeon, but it would also be considered to be administrative. While you would be able to claim that you're unable to perform the duties of an orthopedic surgeon, and the carrier, and when I say carrier, I mean insurance company, would go ahead and pay you, were you to return to some other type of administrative duties, like let's say that you do utilization review for an insurance company, I think it would invite increased scrutiny of your claim, increased and prejudicial scrutiny of your claim, where the insurance company would say, well, you did administrative duties before, you're doing administrative duties now, there are still some of the important duties of your previous occupation that you're able to perform. And we don't consider you to be totally disabled. So for this question, I think it's really important that you speak with an experienced attorney and discuss what your options are. And that's not to say that you can't go on to some other career, but you have to take into consideration all the facts and the totality of the circumstances of your case before going on to another different occupation to ensure that your claim isn't jeopardized. And I have a client, he was a very successful dentist. I'm not going to say where, I'm not going to identify whether it was a man or a woman. And this dentist was a clinical dentist, a chairside dentist. All he did was drill and fill prior to his disability. Subsequent to his total disability, he went on to buy and sell practices. It had absolutely nothing to do with what his duties were immediately preceding his disability. He's gone on to be very successful in his second career, and he's collecting his disability benefits. Carriers and insurance companies hate this, but it's the terms of their contract. But before making that leap, you really ought to speak to someone very qualified to evaluate whether this would be a wise move. Well, I have to say that this question comes up all the time. Most individuals, particularly doctors, lawyers, financial professionals, in addition to having private coverage, will have group long-term disability coverage. And one of the distinguishing features of group long-term disability coverage is that the carriers who issue those policies love corporate welfare. And they seek to reduce the monthly indemnity that they have to pay to a claimant by the amount that that claimant receives from Social Security. So the brief answer is, yeah, you're going to have to apply for Social Security disability. Because if you fail to do it, Most policies, and when I say most, I haven't seen an exception, will reduce your monthly benefit by the amount that the carrier assumes that you'll receive from Social Security. So if you fail to apply, your benefit is going to get reduced. Most policies require that you not only apply, but that you actually pursue a Social Security disability appeal. And if that's denied, then they'll drop the requirement. Additionally, and you should know that not only will most insurance carriers reduce your benefit by the amount that you receive from Social Security, but also the amount that your dependents receive due to your disability from Social Security. And really, one of the most important things that I want to leave you with in response to this question is that quite often when Social Security disability is approved, they will pay you in a lump sum check. Sometimes it's $20,000, I've seen $30,000, I've seen $40,000. It's really critical that you not go out and spend this money. Chances are you're going to owe it to the insurance company. And I've had clients who have received their checks, and despite my admonitions to the contrary, have gone out and used it for whatever debts they have. And it turned out to be an unwise move. And the carrier will then stop paying benefits until the amount of the Social Security benefit has been accounted for. So yeah, if you've got a policy that requires you to apply for Social Security disability, you have to apply for it. Well, this is a really important question, and I am seeing so many of these questions lately. Rescission is a device whereby the carrier will say, the insurance company, the carrier, will say, hey, when we entered into this contract, we relied on your application for the policy, and now that we're looking at everything, we think that you gave us some incorrect information. And had we known this information, we either would not have issued this policy, or we would have issued a policy at a higher premium, or we would have put in an exclusion in the policy. And because you misrepresented this information, we are no longer bound by this policy. And most often, when an insurance company rescinds a long-term disability policy, they'll send that letter outlining the information they relied on and why they're rescinding. It's called a tender. They will tender back the premiums you have paid thus far. So if you disagree with them, the first thing you do is don't cash the check. By cashing the check, depending on what state you're in, may well ratify the decision and show that you agree with it. The next thing you should do is really contact an attorney who understands rescission. I've handled numerous rescission cases throughout my career, and there's a lot of issues here, and I'm going to just bring up some very basics. Every long-term disability policy that I have seen contains something called an incontestability clause. I'm not going to go into the details of the incontestability clause right now, but essentially it has two different standards. If the insurance company rescinds within the first 2 years that the policy is in force, it can deny your claim. Of course, you're making a claim, but it can also rescind the policy for any material misrepresentation, no matter how innocent. Let's say you make a mistake on the application and you represent your income as being too high, or let's say that you forgot that you went to see a spinal specialist 5 years ago for an ache that you were having. No matter how innocent, if it's a material misrepresentation, they can rescind the policy. And what do I mean by materiality? Well, materiality means that had the carrier known, they would have issued a different policy or not issued a policy at all, or issued a policy maybe with a higher premium. That's during the first 2 years that the policy is in force. After 2 years that the policy is in force, the carrier has to demonstrate that you committed fraud. I'm not talking about criminal fraud, I'm talking about civil fraud. And it's much more difficult to rescind a policy after it's been in force for 2 years. They have to show that you made a material false statement, right? That's the element that we just discussed during the first 2 years. That you knew the statement to be false, that you intended, by writing down the wrong answer, you intended to deceive the insurance company, that the insurance company justifiably relied on the false statement. For example, if you applied for a long-term disability policy and you accidentally added a few more zeros to your income and represented that you make $1 billion a year, and the insurance company relied on that, that's going to be difficult for them to justify to a court that they thought you were making $1 billion a year. They haven't justifiably relied on that false statement. Then, of course, damages is the fifth element. It's called the 5 fingers of fraud. Just about every state has a version of this. So before you respond to the insurance company, oh, and by the way, if you get one of these letters, do not write back to the insurance company immediately and contest it. You may make a statement which could really prejudice your right to keeping the policy and ultimately receiving your long-term disability benefits. This is one claim where you ought to immediately call an attorney, like me, or someone who's very familiar with the elements of fraud and insurance. Well, this is an interesting question. And generally speaking, an insurance company is entitled to review really any of your medical records that are remotely related to your claim. For example, if you have Parkinson's or some other neurological disorder, certainly the carrier has a right to see the records from your general practitioner and your neurologist, your orthopedist, maybe even your urologist. But really, they don't have a right to see your psychological records. If you can imagine that you suffer from something like multiple sclerosis and they want to see the records from your dentist, wait, how relevant is that? There's 2 reasons why an insurance company wants to see your psychological records. One is people tend to be open and free and discuss their feelings with their mental health professional. And one reason the carrier wants to see this record is you may make admissions against interest. All right, there may be something in there that they can use against you to deny your claim. The second reason, and more nefarious reason, is that long-term disability insurance companies love to blame physical disabilities on mental disorders, and they call it a somatoform disorder. A somatoform disorder is a mental health condition that causes an individual to experience physical bodily symptoms in response to psychological distresses. And they like to categorize your physical disability as a mental disability because it offers them a few advantages, particularly where they can say that all you have to do is take care of the psychological condition and, your back is going to be fine, your multiple sclerosis is going to go away. Also, a lot of policies will have limited 2-year pay period for psychological issues. The funny thing is this, and I've been doing this for 3 years. I see this applied against women about 3 to 1 against men. They seem to always think that females with some kind of physical complaint, the long-term disability insurance carriers love to think that it's all in their head. It's a sexual bias that I've noticed over the years. So what do you do is the ultimate question. And the thing is, it depends. You never want to outright deny a carrier access to certain records. They may deny your claim on your failure to be cooperative. I think the best answer here would be to negotiate with them and say, why do you want to see these records? They don't contain anything relevant to my condition. And if ultimately they continue to press you for your psychological records, I would say get them first and redact them. Redact anything related to other people, your personal life, and send them in that way along with a letter saying, I've redacted these records because they discuss other people, they discuss things that aren't relevant to this claim, and you don't have any right to know. But again, this is really something an attorney ought to do because you don't want your claim to be denied due to failure to cooperate. One other point here is no matter how hard it is, always be pleasant to the carrier, be professional, never lose your temper. It's not going to get you anywhere. A long-term disability insurance carrier is allowed to investigate your claim for as long as they are paying you and ask you for ongoing proofs of loss. And sometimes this seems kind of ridiculous. For example, if someone has lost their eyesight and they're completely blind, why does the insurance company keep asking for monthly attending physician statements? It's not like you're going to become miraculously sighted again. But they're allowed to do it. There's an element of reasonability built into their investigation. And typically, I would think it would be reasonable to ask you or ask any claimant for a monthly claimant statement. Identifying if you've gone back to work, identifying what doctors you've seen, identifying what alternative treatment modalities you've sought. I think it's a pain in the neck, but I don't think it's unreasonable from a legal standpoint. Also, they're allowed to continue to subject you to what's called an IME. Insurance companies call it an independent medical evaluation. I don't think it's either. Really, it's not independent, it's not medical. I call them insurance medical evaluations because that's what it is. And they can ask you to go to, an IME once, maybe even twice a year for the duration of your claim. The reality is that once an insurance company becomes convinced that you're disabled and it's going to be of a long duration, the insurance companies aren't going to want to continue to invest money in it. So ultimately, and it's been my experience, they'll put you in something called an EDU, an extended duration unit, or a SAM unit, stable and mature unit, where your claim is subject to less intensive scrutiny. And all they really ask you for is a yearly claimant statement. So it's a burden borne by the disabled, but it's something you're going to have to do as long as it's reasonable. And I've outlined the details of what I think is reasonable here.